Alright guys, so we're going to continue our video series here. Right now we're going to do Chapter 5, which is Methods of Ownership. So this in your textbook will be page 197. So again, we'll try to keep this video under a half hour just to give you a recap of Chapter 5 in case you need some review, or in case you use one of your 5 absences on this class. So we'll go over the information now. So Methods of Ownership, you'll see right there at the top in the first paragraph, it talks about severalty ownership versus concurrent ownership. And when you guys see severalty ownership, don't get confused because the word starts with several, and many people start to think, well, that must be many people own it. Severalty, think to sever your common ownership interest, like to cut ties, basically. So ownership in severalty is ownership by one person and one person only. So if one person's name appears in the deed to the exclusion of all others, we would call that ownership in severalty. And then concurrent ownership is ownership by 2 or more people. And there's a few examples we're going to go over for that. We're going to talk about tenancy in common, we're going to talk about joint tenancy, going to talk about tenancy by entirety. So, but a broad definition for that, concurrent ownership, is ownership by 2 or more people. So what I'm going to do now on the board behind me, this is the only thing I'll write on the board for this chapter right now. Again, there's going to be important stuff that I don't write on the board, but for time's sake, I'm just not writing stuff on the board, except if I want to put a chart up. So I'm going to put a chart up behind me now on joint tenancy versus tenancy in common. In my personal opinion, for test purposes, I think the best way to remember this is just remember one of them, and remember that the exact opposite is true for the other. So joint tenancy and tenancy in common are pretty much, for the most part, complete opposites of one another. So I think for test purposes, the best way to remember this is to fully memorize one, and just keep in mind that the exact opposite is true for the other. So we're going to go over this now, joint tenancy versus tenancy in common. So right side of the board here, we will have joint tenancy, and left side, tenancy in common. So the first thing I would say to note for joint tenancy is that joint tenancy has the right of survivorship. What the right of survivorship means is that if you were to have, let's say, 3 concurrent owners in a joint tenancy, well, each one would have equal interest because joint tenancy requires you to do so. But what the right of survivorship states is that if one of those joint tenants dies, they do not pass on that interest to their family member, to their spouse, to their children, to their heirs, but rather, as soon as they die, their ownership interest goes to the surviving joint tenants. So joint tenancy has what we call the right of survivorship. And what that means is that when one joint tenant dies, their interest does not pass on to their family, to their heirs, but rather it goes to the surviving joint tenants. So first and foremost, joint tenancy has the right of survivorship. Now remember, as I said, the exact opposite is true for tenancy in common. And to be honest with you, I'm watching myself record this right now. I don't even know if you guys can see this, but if you can, that's why I'm explaining it as well. But again, joint tenancy has the right of survivorship. The exact opposite is always true for tenancy in common. So tenancy in common, there's no right of survivorship. So under a tenancy in common, if we had the same example, we had 3 owners in a tenancy in common. When one of those tenants in common dies, there's no right of survivorship, which means they can pass it on to their heirs upon death. So tenancy in common, they might say, like, give you an example, like John Smith and Jane Doe are buying property. They want to know how they should own this property so that if one of them dies, they can pass it on to their family, to their heirs. Their attorney is most likely going to recommend they own the property in. The answer will be tenancy in common. So tenancy in common, no right of survivorship here. So tenancy in common, no right of survivorship. So that's the first for both. Second, if they were to ask you, what's the ownership percentage requirement? So for joint tenancy, you absolutely are required to have equal ownership. So if you have 4 joint tenants, each one's 25%. You got 2 joint tenants, each one's 50%. You got 10 joint tenants, each one's 10%. Joint tenancy requires equal ownership. So joint tenancy would require equal ownership. So this here requires equal ownership. Whereas tenancy in common does not require equal ownership. Now here's the thing, in a tenancy in common you could have equal ownership, it's just not required. So in a tenancy in common you could hypothetically have two owners that own it 50-50, that's okay. You could also have two owners that own it 60-40, 70-30, 80-20, so on and so forth. The dead giveaway, I would say, is that if you ever see two or more owners owning property together and the ownership interest is unequal, it's got to be tenancy in common. However, if you see four owners that all have the same ownership interest, you can't say, oh, that's got to be joint tenancy. Not automatically, because tenancy in common could have equal ownership, it's just not required. So number 2 here for tenancy in common, equal ownership is not required. You could have it, but it's not required. So giveaway on the test, if there's ever two or more owners who own property together and there's an unequal ownership interest, it's going to be tenancy in common. So tenancy in common, equal ownership not required. Now, kind of a term that stems off number 1 here, the right of survivorship. If they were to ask you, can a joint tenant devise their interest to their heirs? And we spoke about this already, but I just want to make sure you guys know what the word devise means. Devise means to gift property to your heirs through your will. So under a joint tenancy, you cannot devise property to your heirs due to the right of survivorship. Right of survivorship says that when I die, this property is, instead going to go to the surviving joint tenants. I cannot devise it to my heirs. So I'm going to write that here. So under a joint tenancy, you cannot devise your interest to your heirs. So number 3 here, cannot devise interest to heirs. Whereas in a tenancy in common, you can devise your interest to your heirs. Why? There's no right of survivorship. So when I die, I give the property to whoever I want to. And again, just keeping along with our theme here, whatever's true for one is the exact opposite for the other. So number 3 for tenancy in common, you can devise interest to your heirs. Number 3, can devise interest to heirs. So that's number 3. Number 4, they might ask you, who cannot be involved in a joint tenancy? You cannot have a corporation involved in a joint tenancy, and that's due to what we call their perpetual existence. What perpetual existence basically means is that the corporation would always outlive the natural person. So if you had a corporation involved in a joint tenancy, and you had a corporation, John Smith and Jane Doe, who's always going to be the lone survivor at the end? The corporation. Corporation doesn't have a pulse. The corporation has what we call perpetual existence. It continues to live on. So if they were to ask you who cannot be involved, what type of entity, person, whatever cannot be involved in a joint tenancy, the answer would be a corporation. In a joint tenancy, you cannot have a corporation, and the reasoning, if they ask you, is due to what we call their perpetual existence. The corporation would always outlive the natural person. Number 4 here, cannot have a corporation. And again, you cannot have a corporation due to what we call their perpetual existence. Now, again, keeping along with the theme, the exact opposite is going to be true for tenancy in common. In tenancy in common, no problem, you can have a corporation. So, tenancy in common, you can have a corporation. So again, in a tenancy in common, you can have a corporation. Now, the 5th thing that we're going to talk about here is the only commonality that they have. So, under a joint tenancy, you're required to have what we call unity of time, title, interest, and possession. And what that means is that everybody must, be put in the same title at the same time, have an equal ownership interest, and an equal right of possession. What an equal right of possession means is that if I'm a joint tenant and I have 10% ownership, and the other joint tenant has 90%, even though I'm only a 10% owner, I have rights to use and occupy 100% of the property. That's what the right of possession means essentially here. So, and I'm just going to write this up here. So for joint tenancy, you would have unity of time, title, interest, and possession. Whereas with tenancy in common, the only commonality you do have is tenancy in common has the same thing, that unity of possession. So in a joint tenancy, obviously everybody would have equal ownership. The example I gave before would have been for tenancy in common. If you had that 90-10 ownership, 90-10 ownership under a tenancy in common, the 10% owner has rights to use and occupy 100% of the property. And also, what that has to, kind of go along with as well, is that, one joint tenant or one tenant in common cannot sell the entire property by themselves without getting the authorization of others. You could sell your share by yourself, but you can't sell the entire property by yourself. So just to write this up here, joint tenancy has unity of time, title, interest, and possession, whereas tenancy in common just has the unity of possession. And again, what that also means is that if I'm a joint tenant or a tenant in common, if I'm a 10% owner in a joint tenancy, which would mean I have 9 other partners, we each have 10% ownership, or in a tenancy in common, let's say it's a 90-10, and I happen to be that 10% owner, I could always sell my share, whether it's joint tenancy or tenancy in common. I could sell my share, but I cannot sell the entire property without having the authorization of others. And we'll talk about that in a second, but for right now, I'm going to write down for joint tenancy, you have to have the unity of time, title, interest, and possession. So joint tenancy, here you have to have the unity of time, title, interest, and possession. So again, joint tenancy, unity of time, title, interest, and possession. Tenancy in common, if you want to write down one thing for that, the only commonality that they happen to share, tenancy in common has the unity of possession. I don't know if you'll get this cut off here, but I'll just write it anyway. Unity of possession. So again, as I said, a joint tenant and tenant in common could sell their individual interest in the property. They cannot sell the entire property without getting consent of everybody, though. I'm going to give you guys an example of what happens here if a joint tenant were to sell their interest, because the thing is, if a joint tenant sells their interest, for a joint tenancy you have to have unity of time, title, interest, and possession. You would have broken the unity of time and title at that point in time. So what winds up happening? The joint tenancy is broken. So we're going to go over an example of what would happen there. So get this up here now. So let's say we have an example, A, B, and C own property in joint tenancy. Well, if it's joint tenancy, they have to have equal ownership. So roughly it's going to be 33% apiece. So we got 33 here, 33 here, and 33 here. Let's say C wakes up one morning and says, you know what, I want to sell my interest off to D. D is offering me a good price. So C sells their interest off to D. D gets that 33% ownership interest. However, D now becomes a tenant in common with A and B, who remain as joint tenants, but just between themselves. So when C sells off to D, A, B, and C were joint tenants. When C here sells to D, D becomes a tenant in common with the remaining owners, A and B, who remain as joint tenants, but just between the two of them. So I'll go through the next step here. So now D gets a 33% tenancy in common. A and B remain as 33% owners, but they are joint tenants just between the two of them. So what now happens in this circumstance here, let's say B were to die. If B dies, who's their ownership go to? Well, it doesn't get split evenly between A and D in this circumstance because D is a tenant in common with A and B, who are joint tenants but just between the two of them. So if B dies here, their interest goes to A. So A would now be a 66% owner and D a 33% owner. And what type of ownership is this? It's tenancy in common. And the reason that they give away for that, it's unequal ownership interest. If it's ever an unequal ownership interest, it's always going to be a tenancy in common. Joint tenancy, you have to have an equal ownership interest. So this is tenancy in common versus joint tenancy, the basics of it. If you guys flip your page now and go to page 198, on 198 it talks some more about that, about the unity of time, title, interest, possession, things that we just spoke of. But on the top right of 198 here, it goes over a term called partition. And what partition is, it's the process of concurrent owners, which means, two or more owners of a property, concurrent owners getting together and through court order trying to seek to sever their common ownership, remember, sever, cut their common ownership, cut their ties between each other, and own their fraction of the property in severalty. So, just to put another example up here, let's say we have A, B, and C. Again, they own property in joint tenancy. And for argument's sake, let's say that they own 3 acres together. 3 acres in joint tenancy. A, B, and C get together and say, listen, the town has a requirement that minimum lot size is 0.5 acres. Wouldn't we each rather own 100% of 1 acre than 33% of 3 acres? And they all kind of agree on that, and they seek to subdivide the property. The subdivision is successful, and now what they've agreed on is that A is going to get lot 1, B is going to get lot 2, and C is going to get lot 3. Each lot is 1 acre each. They're now each going to own 1 acre in severalty completely and totally by themselves due to this process called partition. And the definition of partition, if you want to highlight it, it's on the top right of 198 here. So again, partition is a legal process when you get concurrent owners who come together and seek to sever their common ownership, in other words, end their joint tenancy, and own their fraction of the property in severalty. Severalty meaning by themselves. And that's what you'd be trying to accomplish in the case of partition there. So let's go to the bottom right here of 198, and it talks about tenancy by entirety. So I'll give you an easy way to remember this. Tenancy by entirety is really essentially the same exact thing as joint tenancy, but just between a husband and a wife. In the state of New Jersey, when a husband and wife take title, they automatically take it as tenants by entirety unless they specifically know otherwise with their attorney. And maybe they would know otherwise with their attorney that they want to take it as tenancy in common because it's their second marriage, it's an investment property, and they want to make sure if they die, they can pass it on to their children from their first marriage, you know, something like that. But automatically, in New Jersey, when a husband and wife take title, it's automatically tenancy by entirety unless they specifically noted otherwise. So tenancy by entirety, you know, pretty much follows the same exact rules as joint tenancy, but just between a husband and a wife. And one of the other differences I would say is that in a tenancy by entirety, you cannot seek partition. In that case, partition is most likely going to be referred to as divorce. So let's turn the page. Let's go to page 200 here. Now, 200 talks about ownership of real estate by business entities, and this is probably more important for the broker's test, and we're focusing on the salesperson's test now. If they were to ask you about this, whether it be the broker or salesperson's test, it's pretty basic stuff. So, like, you know, sole proprietorships, what's the biggest negative of that? Unlimited liability. If you own something under a sole proprietorship, if they want to sue your business, they could also sue you personally. That'd be a big negative of that. Corporations, you have C Corps and S Corps. C Corps, one of the negatives behind that is double taxation. You get taxed at both levels there. LLCs, I would say that, you know, they're rather common. They're pretty easy to create. It's a limited liability company, so you get some of the tax benefits of partnerships and the limited liability components of a corporation, so it kind of gives you a little bit of the best of both worlds. And then, if you get to page 201, it starts talking about partnerships. So partnerships in a couple forms here, you know, a general partner, limited partner agreement, just a regular partnership, and syndications here as well. So one of, you know, if they were to ask you about this, I don't think they're going to go into too much details on syndications. I, you know, talk about syndications in class. I make mention and I teach syndications in class, the basics of, you know, the 506B, 506C as we have in the book. But, you know, again, I don't think they're going to go into details like SEC requirements and filings and accredited investors, sophisticated investors, things like that. I think they'll try to keep it very basic for you, and that's the purpose of this video for test purposes. You know, for partnerships, you have general partners and limited partners. And if they were to ask you what the difference is there, general partners, they are involved in daily operations. They make decisions and financially invested. Whereas limited partners, their only liability is just their financial investment. So as a limited partner, if I invest in a partnership and I give the GPs, the general partners, my money, let's say $100,000, that's my liability. You know, everything can go wrong, but the most that I can lose is my $100,000, my initial investment. I take on no additional liability. So general partners, though, being that they're involved in, you know, daily operations and running the show, they have liability on top of their financial investment. So general partners, financially invested and involved in daily operations. Limited partners, their liability is limited strictly just to their financial investment. Then top right here of 201 talks about REITs, real estate investment trusts. So in regards to a real estate investment trust, partnerships have a couple more tax benefits via syndications. We won't get into those now. But in general with REITs, if they were to ask you about REITs, they might say, which of the following is most similar to a real estate mutual fund? And that would be a REIT, a real estate investment trust. So again, if they were to ask you which of the following is most similar to a real estate mutual fund on the test, that would be a REIT. And again, a REIT is a real estate investment trust, if they were to ask you any questions on that. All right, so let's go to the bottom of page 201 here, and it talks about condos here. So in regards to condos, they could potentially ask you 2 questions there, maybe 3. So condos, they might ask you, how is condo ownership transferred? It's transferred by way of a unit deed. This unit deed, the whole purpose of it is basically to tell you that you own your interior walls. When you buy into most condo communities, you can't change your roof, you can't paint your exterior, you can't change your driveway, plant your own plants, decorate it even around the holidays. So there's a lot of different, regulations. We call those the bylaws. The bylaws tell you what you can and cannot do in these condo and townhome communities. But condo ownership, if they ask you how is it transferred, it's transferred via a unit deed. So a unit deed would transfer condo ownership. And then, if they were to ask you what regulates condo ownership, it's called the Horizontal Property Act. So again, the Horizontal Property Act, that would regulate condo ownership, if they were to ask you any questions on that. So let's turn and go to page 202 here. On page 202, it talks about more stuff about condos, about the bylaws. So again, in previous videos, we've talked about bylaws. If they were to ask you questions on that, what bylaws basically do, they're the rules and regulations of the condo or townhome community. They basically tell you what you can and cannot do. Sometimes they're also referred to as the CCRs, which stands for covenants, conditions, and restrictions. So again, sometimes they call them the CCRs, covenants, conditions, and restrictions. So go to page 203 here. It talks about co-ops. Now, co-ops are pretty unique because technically when you buy a co-op, you're actually buying shares of stock in a corporation. So when you buy into a co-op, what you receive is you receive what we call a subscription agreement. The subscription agreement gives you basically the rights to shares in the corporation. So the transfer of shares of stock in the corporation we call a subscription agreement. And along with that, we get what we call proprietary lease. The proprietary lease gives you the rights to one particular unit. So in regards to the co-op, the subscription agreement is me purchasing the shares of stock in the corporation. And along with that, again, I get the proprietary lease, which gives me the rights to one particular unit. So that's the co-op there. So again, ownership in a co-op, you're buying shares of stock in a corporation, transferred via a subscription agreement, and again, along with that, you get the proprietary lease, which gives the rights to one particular unit. And if you turn the page here, go to page 204, it talks about timeshares, timeshare act, and things like that. Timeshares aren't all that common in New Jersey, but I can tell you this, that if you are selling timeshares in New Jersey for New Jersey properties, you are supposed to have a real estate license. So let's say I'm selling timeshares in Atlantic City for a commission. If I'm doing so, I am supposed to have a real estate license. A lot of different intricacies with timeshares. I would just say the number one thing to know for them, though, for test purposes. If you are selling timeshares in New Jersey for New Jersey properties for a commission, you are supposed to have a New Jersey real estate license. So that is our quick recap for Chapter 5. Hopefully this serves as a good review for you guys. So if you guys have any questions when looking over this video, as always, feel free to email me. My email is just simply kylekovats@gmail.com. Thank you, guys.